Your Honors, we are here today on Mr. Henderson's second appeal in this case. I represented Mr. Henderson on the first, and we are asking this court today to reverse and impose concurrent sentences in Mr. Henderson's sentencing-only appeal in this case because the trial court erred in imposing consecutive sentences. I know the court is familiar with the briefs, but I'll give a brief recap of the procedural history and the facts of this case. Mr. Henderson, in his first appeal, was sentenced when the trial court sua sponte ordered that he serve as a range 3 offender, and this court sent this case back after finding that the foreign convictions test did not bear out that this should be a range 3 sentencing, and sent this case back with instruction that the trial court sentence Mr. Henderson as a range 2 offender. In doing so this time, the trial court found that Mr. Henderson had an extensive criminal history, and therefore consecutive sentencing was justified. Also, that he was someone from whom the public needed to be protected, so it ordered sentences to serve. And in doing so, it also found that Mr. Henderson should serve the maximum in-range sentence for both of the offenses. We are here today not to argue that the trial court erred in imposing or finding that there was an extensive criminal history. The record bears that out. What we are arguing today is in looking at the mitigating and enhancing factors, and in looking at the facts of the case, and in looking at whether or not this case, even though consecutive sentencing was on the table, should be applied, given the overall sentencing considerations that this should be the least severe measure necessary for the punishment and for the offense, and that the facts of the offense justified the length of the sentence that was warranted.
It looks like in your brief that you're arguing only a failure to articulate on the record the parsimony finding. Is that true?
To some degree, yes.
So that's one of our principles of sentencing. Are trial courts required to identify expressly on the record that they have considered each specific principle of sentencing?
No.
All right, so why are we singling out the parsimony provision for special treatment?
Could you repeat that, Judge Green?
No,
sorry, a little louder.
So the parsimony provision, that would be the least severe sentence necessary
Correct.
to accomplish the goals of sentencing in the particular case, which I understand here to be protection of the public.
Correct.
That's one of several principles of sentencing that are laid out in 4035-103. And I think you just conceded that the trial court doesn't need to make an express finding on the record that it has gone through each principle of sentencing in section 103. If that's the case, why is it then that the trial court is required to make an express finding that it's complied with the parsimony provision here, but not identify other principles of sentencing that it's also complied with?
The trial court has an obligation to make sure that at the end of all the math that it does with the sum, I couldn't believe it when I wrote it down, but the 35 considerations that they have to go through in determining length of the individual sentences, whether or not it should be probation or whether it should be a sentence of confinement, whether or not it should be consecutive or concurrent. At the end of that, it's got to make sure that the individual math adds up to a sentence that that provision is a grounding basis. And the trial court doesn't need to make sure that it complies with every single one of those, but it needs to make that finding at the end of its calculus. And the trial court didn't do that.
Can the finding be implied from the record?
No.
Is there case law that suggests that it can?
No, but I would argue that
there's no case law that suggests that the parsimony finding can be made, an implied finding can be made from the record?
There's no case law that says that. Could you,
I'm sorry, I'm not speaking loud enough, and I apologize, Ms. Donner. There's no case law that suggests that the parsimony finding couldn't be implied from the record?
That the trial court, just by saying that it considered the purposes and principles of sentencing, for this court to review it to make sure that it's adequate under FIS, that can be implied by this court?
Yeah, I think, and help me with this, because I'm just trying to figure out the parameters of the argument. I think you're arguing that there has to be an express finding of compliance with the parsimony provision. And I'm sorry. If that's the argument, I'm asking, is there any case law that suggests that we could uphold a sentence if the finding is implied from the other court's findings?
I would say that there's case law that indicates that the trial court is responsible for making sure that we have on the record reasons that we can look at, this court can look at, to say this trial court went through every single one of these considerations, not necessarily every single 35 or whatever that they are, but the trial court had a basis for ordering consecutive sentencing, had a basis for it. It needs to be adequate so that this court can consider it, because we're not in the trial court and we can't read their mind. If you're asking if there's case law that excuses a trial court.
Not that excuses, that it finds that the finding actually was made, but that it's not articulated on the record as a finding.
I think I don't know of a case, but I think that is a dangerous path to go down, to imply that the trial court, just by saying that it considered something, I consider I meant to call it the colloquy, but I guess that's more of a conversation than a recitation, but that's a dangerous path to go down, to say that the trial court, this court can imply or find that it is implied by a trial court just saying that they considered it. There has to be something on the record. Even if it's just, I find that it's an extensive criminal history, because in Mr. Henderson's case, he had 15 misdemeanors and 4 prior felonies in Tennessee. That additional step is something that allows us who are not in the courtroom to find under bias that the trial court had a legitimate reason and did not, and chose to took the path that it did. I think that's fair to appellate review, and I think to imply anything from the trial court considering that is a dangerous proposition. But no, to answer your question, Judge Greenholz, I don't know of anything specifically.
Could the trial court adopt, I don't need to ask all the questions.
No, you're good.
Could the trial court have readopted its findings from the first hearing in terms of a need for confinement, in terms of a lack of ability for rehabilitation? Could it have readopted the findings from the first hearing?
I don't think so in this case. This
Okay.
trial court.
It did though, right?
It did, but, and I'll clarify, this court ordered the trial court to resentence Mr. Henderson as a range 2 offender. And the state did not elect to put on new proof, but Mr. Henderson did. The trial court at the outset of this transcript attempted to impose the 18-year sentence that it originally ordered Mr. Henderson to serve without making any other findings before the state corrected it and corrected the trial court and said, actually, the range of years has altered on a range 3 going down to range 2, and instead of the 12-year sentence that you imposed, the range on a range 2 defendant for a Class D felony would be 8 to 4 years. So that's no longer a possibility. So the state had to remind the trial court, because I think what it was going to do is impose the same term of years with the adjusted 35% from 45%
So in the,
release eligibility.
in the first hearing, the trial court made this finding, and I want to see if the trial court had made a similar finding in the second hearing, whether you think it would have complied with its duties to announce on the record its compliance with the parsimony provision. So in the first hearing, the trial court said, felt like that the overall total effective sentence in this case was appropriate, given his prior criminal history and given the fact that he was on probation and was also out on bond when he committed all of these offenses. So would a justification or a rationale for consecutive sentences with those findings, does that comply with the parsimony provision in your mind?
No,
Okay, why not?
and I'll explain why. The out on bond applied to these offenses were mandated to run consecutive under Tennessee Rule of Criminal Procedure 32, I believe, if you're out on bond at the time. Out on bond for a felony or on a form of supervised
Yeah,
release.
I'm not arguing the other I'm not arguing anything, but I'm not referring to the other categories. Just with respect to the finding that the trial court has to make that the overall total effective sentence is the least severe measure necessary to accomplish the goal of long-term incapacitation. Does this finding satisfy the requirement? Okay.
No, I don't. I still think at the end of all the things that it does, that provision at the outset of the sentencing title, the 30, 40, chapter. Anyway, excuse me. At the outset of that says, at the beginning of this, it's a grounding basis for all the tedious things that we can get into with the enhancement factors and the mitigating factors and everything. At the basis, at the end of this, you've got to circle back around and say, all right, I'm looking at a case where a man who testified that twice that he was diagnosed as schizophrenic 8 months before this offense, who harmed no one, and at no point, other than being blue lighted because a police officer had a bolo for a car being taken from a gas station, sped, attempted to evade did he speed or exceed the speeding limit or commit any other driving infractions that would have given the police officer a reason other than the bolo to pull him over. He got out of it, he pulled over, it came to a peaceful stop. The owner of the car got his property back within 30 minutes of the taking. That's what that provision is. Whether or not we're looking at someone who, yes, has all these convictions, may have evinced, as the court said, rehabilitation is not going to work for him, and said he's someone from whom he has given multiple chances to be on probation. You've got to circle back and look at the fact that this is a man that you're putting in jail because he is schizophrenic, which the DSM states he's been diagnosed twice, unchallenged by the state, that he was schizophrenic at the time, that he said he was using marijuana and methamphetamine while he was on the stand, and that society needs to be protected from a man who, one, is suffering from delusions and hallucinations, posed no danger. It was charged as an evading Class E, so there was no risk of danger to any of the bystanders that were around at the time. Whether or not that's someone from whom a 12-year sentence is appropriate or an 8-year sentence will do it. And I think if you're looking at it that way, I think that particular purposes and principles of sentencing thing is a grounding thing for the trial court to help it, rather than say, all right, you've got to consider one last thing. It's like, all right, we know you've got all these things that the legislature has said you have to consider, but let's circle back and look, what are we actually doing here? Is this helping somebody? Is this helping a man? Or is this protecting a society from a man who has delusions and is paranoid and is in prison getting no treatment? Which is not in the record.
In your view, if you're helping us write the opinion, what is the rule that you wish us to write? That the parsimony provision must be stated on the record, or compliance with the parsimony provision must be stated on the record? That it has to be something more than, I find that the total effective sentence is the least severe measure necessary to accomplish the goal of long-term incapacitation? What else does, in your view, what else should we put in the opinion to require trial courts to say?
There needs to be, Judge Crucial, there needs to be something that says at the end of a sentencing, or at the end of the sentencing hearing, the trial court, which it's already has to abide by, is to look at this statute that's been put in place that's at the very beginning and says, this is why everything else that you've had to consider exists. And if you can pick from one of the 6 or 7 that says this, and looking at this, this is why I think this sentence is fair, this is why I think society needs to be protected. If you can look at one of those and put that on the record, I think that's adequate. I think it's a statute that must be considered as part of sentencing.
What Supreme Court case that follows bias tells us that we have to do that, or that the trial court has to do that, excuse me?
Has to consider a statute?
Has to make that,
Has to put it on the
has
record.
to put that finding that you just described. I mean, he said, help us write an opinion, and you spoke very eloquently on what you would like to see, but and I'm not saying you're wrong. I mean, I understand exactly what your point is, but since bias, name me a Supreme Court case that says you need to do that.
Well, I would argue that it's not necessarily a case. I think the statute, because it's a law, says that to implement the purposes of this chapter, the following principles apply.
Right, so, but bias and its progeny are pretty clear that they're not magic words that have to be spoken.
Correct.
They're not specific things that have to be said. And basically, I think at the very beginning, Judge Greenhall's question was, you know, can it be implied? I mean, there's plenty of cases where the courts have said, look, while there are no magic words, the trial court did say, I'm following the purposes and principles of sentencing, and then he or she kind of goes into this findings of facts / maybe reciting some facts that were heard at the sentencing hearing or at trial, and this, that, and the other, may reference an enhancement factor here or there, and at the end of the day, they say, here's the sentence. And I'm being a little casual with that. I recognize it. But they don't go through and go A, B, C, D, what, 35 of them you said? 1, 2, 3, 4, 5.
That, yes,
right.
something
They don't
to
do
that
that.
effect.
They kind of talk, and I don't want to say around them, amongst the 35, And then they come up with a number, and case after case after case is affirmed.
I mean, how
And the
do you-
Supreme Court has either taken it and reaffirmed it, or said, there's no need for us to look at this because you've basically, by denying Rule 11, they followed bias. So how are we getting from where we are in the case law to now what you're asking is, I need another paragraph.
Is that I would argue that I don't think that's asking too much when a man's gonna have 12 years.
I'm not saying you're
But-
asking too much, I'm just saying you are asking for a stricter interpretation of the sentencing law than the Supreme Court has routinely upheld.
I would state that I am not.
Okay.
What I would state that this court will have to hold that it is adequate for a trial court, for the purposes of this court's trying to investigate whether or not they put adequate reasonings on the record, whether or not this court is saying, all they have to do is saying, I consider the purposes and principles of sentencing. Whether or not they have any indication that they've looked at anything like this.
Haven't we
And
already?
that's not adequate.
Haven't we held that already in Graves earlier this year?
Haven't we held this already?
I heard this already in Graves. Decision came out February 14th of this
Justin
year.
Graves.
Justin Graves, where this court upheld an implicit finding of compliance with the parsimony provision when the trial court reviewed the failures of previous rehabilitative efforts, as here, continued criminal activity, as here, and findings that the interests of society in being protected from the defendant's possible future criminal conduct are great, as here. Isn't this case just like Graves?
No.
Okay, in terms of implicit findings about whether the trial court complied with the parsimony provision, isn't this case just like Graves?
I would argue not.
Okay, how so?
And I think this case, this court, at the outset of the hearing, indicated that it is, and I know I'm going into my time, I apologize, indicated that it was ready to go ahead and sentence Mr. Henderson to a range 3 sentence again, without even looking at the record. So I think that's a red flag to me, just in this specific case, that the trial court needs to be considering and needs to put findings on the record. Where Mr. Henderson differs for someone like Mr. Graves is, the trial court, we're not fighting that there is an extensive criminal history here, which consecutive sentencing was justified. What we are asking the court to do is to look at the facts, as I've said before, is to look at the facts of the case and to determine that it is something that is warranted, given Mr. Henderson's state and given the nature of the offense and the facts of the offense.
So,
And I think that would be where Justin Graves differed.
let me ask you this, and I'll let you sit down, and we'll give you a few minutes on rebuttal. But basically, it sounds like, I'm going to oversimplify your argument, you just don't like the fact that he didn't give him enough mitigation towards his sentence.
Well, it's not that I don't like it. There aren't findings. There was evidence that they asked for a mitigation factor that no one was injured. The trial court found that, not that it applied, but didn't give it any weight. It just didn't find any mitigation factors applied. And it's free to give it whatever weight it wants as long as it acknowledges that it exists. But it didn't do that there, and it didn't credit Mr. Henderson's testimony, which it's completely free to do. But we do have evidence from 2 pathways letters, or 2 letters, stating that he is schizophrenic.
I guess, and I ask it that way, and I know it's an oversimplification in one sense, but in listening to your argument, it's almost as if you're asking us to reweigh how the trial court worked it, which, regardless of findings and this, that, and the other, the Supreme Court's made it very clear that's not our job.
In fact, it's not even within our authority.
Yeah.
So
Not
if-
within your authority
so if the-
To reweigh.
If the trial court,
Correct.
if the trial court found that the principal purpose of sentencing in this particular case, given needs for rehabilitation, prior criminal conduct, that the principal goal of sentencing was incapacitation, I hear you arguing that the trial court should have said that the principal goal in sentencing in this case should have been rehabilitation and not incapacitation. And I think I hear you argue that we should agree with you and that we should remand it to the trial court and to say, no, the principal goal in sentencing in this case, given the schizophrenia, given the failure at treatment efforts, really is rehabilitation. And trial court, incapacitation was not the true goal. It should have been rehabilitation here. We don't have that authority, do we, or do we?
Well, I would argue that the schizophrenia diagnosis is probably less on the hierarchy than the fact that absolutely no one was harmed. Police officers were not put in danger from the facts of the offense. I think the facts of the offense are the most important thing in determining this and determining whether or not, and circling back to reality after going through all these things, how much time logically or rationally and in accordance with the following principles is this worth for protection of the individuals against whom incarceration is supposed to provide, or that it should be no greater for the offense committed. And we're not asking this court to reweigh anything, to find that it's the job of the state or the court to make an offer of rehabilitation every single time someone comes forward with a mental diagnosis. What we're asking is simply that the trial court put findings on the record that this sentence is justified, given all of the individual things that it has to go through, and looking at it from, not necessarily, I would articulate that all the things in there are the trees, and that this, at the end of the day, the court steps back and looks at the forest.
We'll give you 2 minutes when the state is completed.
May it please the court. Good morning, Your Honors. Davey Douglas on behalf of the state. And this court should affirm the judgment of the trial court because the trial court did not abuse its discretion in sentencing the defendant here. I think the parties are all in agreement that the trial court is not required to expressly articulate that it is considered each and every purpose and principle of sentencing. And Judge Greenholtz, going to your question about is there case law asking if those findings can be implicit, there is. It's the Graves case. That's just one of many. And Judge Dyer, you alluded to those other cases as well. But in Graves, this court stated that while the trial court did not use the specific terminology noted by the defendant, it is implicit in the trial court's findings that the court determined that extended incarceration was the least severe measure necessary to achieve the purposes and principles of sentencing. That's identical to what we have here. We've got a trial court who stated it was considering the purposes and principles of sentencing, and it articulated multiple things that it was considering. Proof at both sentencing hearings, the proof at trial, the pre-sentence report, mitigating enhancement factors, and then it made pretty extensive findings that confinement was necessary to protect society from future harm, and that the defendant's criminal history showed that he lacked the potential for rehabilitation. And based on, again, taking everything together that the trial court put on the record, that's more than sufficient to affirm or to review and then affirm the defendant's sentence here.
Did the findings in the first sentencing hearing have any weight with respect to the second?
I don't believe that the findings in the first one do. I think that was something, though, the court said it could consider the proof from the first one.
The sentencing court said that it reaffirmed what it did in the original sentencing hearing. And then it went further to make the finding that the overall effective sentence was appropriate given the need for incapacitation, essentially. So is that finding that it is reaffirming in the second sentencing hearing from the state's perspective, is that off the table? And we just need to look at what was said in the second?
Well, actually, no, I don't think it's completely off the table, Your Honor. I think since it's reaffirming, that's certainly on the table, but it's also important to focus on those additional findings in the second hearing where, again, we've got those express purposes and principles of sentencing. But no, those first findings are still on the table. And again, based on the defendant's record that we have here, it fully supports the trial court's decision to impose an 8-year sentence and a 4-year sentence and align them consecutively. It's undisputed here the defendant had a very extensive criminal history. He repeatedly committed offenses while he was released on probation, while he was on bail, while he was on bond. Those were all relevant and pertinent considerations for the trial court to make when imposing sentences. And Judge Dyer, going to your question about what has the Supreme Court said that courts need to consider, the Supreme Court has never gone further than Bice, which just says that the trial court needs to consider the purposes and principles of sentencing. And what we have here is more than adequate to show that the trial court made these considerations and therefore did not abuse its discretion by imposing the sentence that it did here.
So the defense seemed to suggest at one point in time during her argument that maybe we should raise a red flag or so based on the beginning of this sentencing hearing, where one could argue that the trial court, okay, you sent it back, I'm still going to max this guy out. And so therefore, we should look at the rest of the hearing under this lens of he was trying to get to a result that he had already made. What's your response to that?
I don't think that the court was necessarily trying to get to a result that it had already made. It did make that comment, but then when the state corrected the court expressly said that it was going to consider the proof presented at the sentencing hearing, the mitigating factors, enhancement factors, and then it went ahead and just made the additional findings that it did in terms of the defendant's potential for rehabilitation and that confinement was necessary to protect society. I think the court's additional findings show that it was making the proper considerations and was not just simply trying to backfill in some justification for a decision that it had already reached.
If the state's position with respect to mitigating factor number one is that that has been waived, if it has not been waived, do you agree that it should have been considered by the trial court?
Excuse me, do I agree?
Do you agree that it should have been considered by the trial court?
I think the trial court stated it found it said it would consider the mitigating factors, and it said that it found none. So I don't think that, no, the trial court was necessarily required to find this factor. And there was...
Would the record support finding mitigating factor number one?
I think it could, yes, Your Honor. It's true that this was a pretty quick offense and that there wasn't necessarily anyone who was directly in danger, but that's also, there's a lot that goes into the offense of stealing a car and then fleeing from the police. I mean, I think there's a consideration to be made that there could have been potential future harm in another situation, or had this one gone on further. But again, even if the court should have applied this mitigating factor and didn't, there's not a reason to set aside the sentence here because we still have multiple applicable enhancement factors that the defendant doesn't challenge. And again, as the court said in Bice, the misapplication of a mitigating or enhancement factor does not invalidate the sentence unless it wholly departs from the purposes and principles of sentencing, which is not what we have here. We've got a sentence that fully complies with the law, and it was one that the trial court had the discretion to impose. So unless there are any further questions, we would ask this court to affirm the judgment of the trial court. Thank you.
Thank you, Counsel.
If I may, Judge Greenholz, are you referring to the Justin Graves that was issued April 27th, 2023?
February 14, I believe.
February 14. Mr. Ridley handled that.
That's okay.
There were
Yeah,
multiple
that's
of
fine.
them.
The reason I mentioned Mr. Graves' case is that as I was taking a look at the argument that you're raising in your brief, it occurred to me, much like Judge Dyer had indicated, that we've addressed this issue. And it's not that the issue, I mean, if I'm the trial judge, I may have a very different take on it. I may agree with what you're arguing, and I may believe as a trial judge that other goals of sentencing are properly furthered in this particular case, the incapacitation. But we're not trial judges, and we're here to review whether the trial court, the sentencing court, is in error because it didn't make an express finding on the record when we've previously held that if it makes other findings, we can infer compliance with the parsimony provision.
And what I would ask, if the court has asked about fashioning an opinion, the one I'm looking at is, I guess, the 27th, but I guess this is another applicable portion of it. Graves is the same trial court as we are here on today. And it says, finally, this appellant argues that the court abused its discretion in failing to make any meaningful findings suggesting that the total and at the time undetermined sentence was justly deserved of the least severe measure necessary, which seems to be the exact same thing as the February opinion. This court further articulates, we disagree. While the trial court did not explicitly find so, we conclude that the record in its totality established that the trial court considered the above sentencing principles. And I know these are unreported cases, but we frequently rely on these for individual facts or the facts of what a case turns on. But if this court in writing could say, if the record established that the trial court considered the above principles, if the court in this opinion could say what those principles or what parts of the record it was relying upon to find that the trial court considered those principles, that would be helpful. And that's all we're arguing, is that make that extra effort or put that finding on the record. If you're going to say that we conclude in its totality the trial court considered the above sentencing principles, what about the record that this court find established that the trial court in Graves and here considered those principles? That's what's helpful. Otherwise, we find that it considered those principles, and that's it, which is why I'm here again making this argument. Thank you all for your time. We ask this court reverse and impose concurrent sentences on Mr. Anderson's case. Thank you very much.
Thank you. Let's call the last case.
Saeed Lagrave versus